All right, thank you for staying with us. A federal high court in Kano State, presided over by Justice Yunusa on Friday, nullified the candidature of Abia State Governor-elect Alex Otti. The court ruled that their emergence was not in compliance with the provisions of the 2022 Electoral Act. It states, quote, the party that has not complied with the provisions of the Electoral Act cannot be said to have a candidate in an election and cannot be declared winner of an election. This being so, the votes credited to the first defendant is a wasted vote, end quote, the judge ruled. The judge, however, said it did not cancel the election, but the candidature of Alex Otti. Joining us in the studio is a lawyer, Inibehe Effiong. He will be helping us understand what is going on, Inibehe. Because another story came out saying that the court said that they did not rule in nullifying Alex Otti as the candidate of Labour Party, so to speak. But help us understand what is going on.
Good morning. Thank you for having me. The report in the media that the learned judge, the Honorable Justice Yunusa, or that the court has come out to say that, contrary to what has been reported in the media, that it did not nullify the Abia State governorship election. As far as I'm concerned, it's just a public relations stunt. It is a report syndicated by the News Agency of Nigeria. I have verified this. It is Nan who wrote this report, circulated it to media houses in the country. But I have before me the certified true copy, the judgment order of the court. This is a certified true copy, signed by the learned judge, the Honorable Justice Yunusa. When you go through the order of the court, the judgment order itself, the court unequivocally held that the primary that produced Alex Otti was voided. The court voided it. The court proceeded to say that even the vote cast in furtherance of the candidacy of Alex Otti and his political party, the Labour Party, are wasted votes. All that is here. So the question is, if the primaries and the candidacy are void and the vote cast for the party is void, what is then left? What the court, however, did was to say that the court will not grant relief 10. And according to the learned judge, Alex Otti, in fact, let me just read it.
Please.
He said that, this is what the court said, this is the 9 holding, that the candidates that participated in the election in Abia State are not parties before this court. As such, the court lacks jurisdiction to make an order for the issuance of certificate of return. They are, however, at liberty to seek the said redress in the appropriate division of the court. My question is, if the court had no jurisdiction to make an order for the first runner-up, supposedly as sought by the plaintiff in this case, to be issued with certificate of return and be sworn in, I think PDP came second in Abia. Now, what was the basis for the assumption of jurisdiction by the court to make findings regarding the validity of the primary, the consequence of the nullification of the primaries and the candidacy on the vote? Because if the court has declared the vote cast for the Labour Party as wasted vote, by the principles set by the Supreme Court in the Yaris case in Zamfara, the doctrine of wasted votes implies that when the vote of a political party is declared wasted, the first runner-up, the party that came second, is deemed to be the party that won the election. So what I see here is, with proper respect to the learned judge, making orders that are irreconcilable. But let us even go to the meat of the matter.
When you say irreconcilable, how do you mean?
Irreconcilable in the sense that, in one breed, the learned judge considered that it cannot give an order for the first runner-up or the candidates who participated in the Abia election, other than the Labour Party and Alex Otti, to be issued certificate of return on the basis that those candidates, the proper parties, were not before the court. Because the court said it had no jurisdiction to do so. So the contradiction is that, or why it is irreconcilable is that, having made that finding, there was no basis, with proper respect to the court, to have even make any pronouncement.
In the first place.
In the first place, regarding the primary in Abia, regarding the candidacy of Otti, regarding the issue of wasted vote. And what I find more intriguing, and I hope that Nigerians and the legal community will find answers that the media will also probe, is that there are litany of questions, germane questions begging for answers. Now, this is the judgment order. When you look at it, it says upon the originating summons dated and filed on the 11th day of May, 2023, 11th day of May. This is a judgment delivered on the 18th day of May. Barely a space of 7 to 8 days. Now, by the pre-election, the Federal High Court pre-election practice direction issued by the Honorable Chief Judge of the Federal High Court, a respondent or defendant in a pre-election matter before the Federal High Court has 7 days upon service of the processes of the court to enter appearance, 10 days to file a counter affidavit to the originating summons. When was, look at the parties, Labour Party is the first respondent, INEC is the second. When were they served with the originating summons? Were they served with hearing notice? How is it, when was this case even assigned? What is the magic that was done, if we are going by the certified order that I have, for this case to have been commenced and concluded? I am excited that in Nigeria, our judiciary can absolutely but here is the most fundamental part of all this. The man who filed this case, one Ibrahim, Haruna Ibrahim, that name doesn't sound like someone from Abia. Clearly, it's not from Abia, it's from Kano. Now, by virtue of Section 84, subsection 12 of the Electoral Act, it is only an aspirant who participated in the primaries of a party that has the local standard to activate the jurisdiction of the court to make any complaint regarding the conduct of that primary. The question Nigerians would be begging for answer is, was Ibrahim Haruna Ibrahim an aspirant in the June 2022 primary of Labour Party in Abia State?
What was his interest in there?
And why was this matter taken to Kano? And why is that Lesotho not a party to this case? But guess what? That is not the end of the matter. By virtue of Section 285, Section 9 of the 1999 Constitution as amended, every pre-election matter must be filed within 14 days of the occurrence of the event complained of. If the issue in contention is that Labour Party had failed to submit membership register 30 days before the primary that produced Alex Otti, because you have to look at it on a case-by-case basis. Now, when exactly was this case filed? Let's even assume that the plaintiff had the locus. Was it brought within time? For a primary that took place in June 2022, and for a judgment that was delivered on the 18th of May 2023. It is simple arithmetic. 14 days had clearly elapsed. The matter was settled bad. And what the Supreme Court has said is that section, when it comes to Section 285, regarding constitutional timeline, either for filing or determination of election or pre-election matter, the Supreme Court says that it is like the Rock of Gibraltar. It is like Mount Zion that cannot be moved. So once this time has elapsed, there is no miracle, there is no voodoo, there is no jurisprudential adventure that can lead to the assumption of jurisdiction. So my humble opinion is that I entirely disagree with the learned judge that this court had no jurisdiction to delve into this matter. But we have to be careful as a country, and sometimes it is even, very painful as a lawyer that we have to even make commentaries about decisions of courts. But the reason why we have to speak about it is that these decisions have profound consequences, not just on the lawyers, not just on my lords, the judges, but also on the country itself. Now, does this have any bearing or consequence on the swearing in of Alex Otti?
Does it?
It doesn't.
Okay.
It cannot stop because, I mean, even...
But it's the pronouncement of the court.
Of course.
Whether it is rightly or wrongly, as the case may be, but it's a pronouncement of the court. Wouldn't there be a counter before the status quo remains?
So my expectation, and I want to believe that process is already ongoing, is that Labour Party will proceed to the Court of Appeal to challenge this judgment. The judgment has to be challenged. But guess what? Electoral has already been declared. Once someone has been declared a governor or for other elective position, it therefore becomes the exclusive preserve of the election tribunal set up under the Constitution to determine whether that person is properly elected or not. The court has not restrained or did not restrain, the Honorable Justice Haruna or Yunusa did not restrain the Chief Judge, the Honorable Chief Judge of Abia State, from swearing in Alex Otti. That is 1. 2. Even on the basis of the last holding, 9 here, the learned judge had declined to make consequential order for any person other than Alex Otti to be sworn in. So by implication...
So it creates a window.
No, it's not even... There is no debate because on the 29th of May...
He will be sworn in.
Ikpeazu's tenure would have elapsed. There cannot be constitutional vacuum in the office of gubernatorial position of governor. Someone has to be sworn in, and that person is Alex Otti because he has been declared the governor. There is no legal impediment. There is no constitutional restraint that stops the swearing in of Alex Otti as that today. But for whatever it is worth, this is a judgment that has to be tested and challenged at the Court of Appeal. But I hope that, and I say that with all sense of respect and responsibility, that the judiciary must also have some form of introspection, some level of self-censorship, because Nigerians are increasingly becoming very interested in decisions of our courts.
Absolutely.
And when decisions such as this are delivered, you know, one Nigerian, the public, begins to really ask whether some of these judgments align with the expectations of the society and the law. So I recommend most respectfully that in political matters, that my constituency, the judiciary, must also listen to the yearnings, you know, of the nation, listen to the voice of the nation, so that we do not give a judgment that, you know, will set the country on fire.
And you spoke to the matter of the attendant implications of judgments like this. And I would like for you to talk to us on the implication on the judiciary, as well as every other attendant implication of judgments like this on the country.
Thank you. One of the implications is that it creates uncertainty in the country regarding what the law is and what the law is not. There should be some appreciable level of certainty on what the position of the law on a matter is. Because when Section 84, subsection 14 of the Electoral Act says it is only an aspirant that can activate the jurisdiction of the court to question or challenge or complain against the conduct of the primary or the procedure for the conduct of the primary, which is essentially what this case was about. And then this person goes to court. Ibrahim Haruna goes to court, not being an aspirant, possibly not even being, you know, having no connection with Abia State. And the court assumed jurisdiction. Matters of jurisdiction, it is a live stream, it is the blood, it is the heart that gives jurisdiction, that gives authority to the court. Once the court has no jurisdiction, everything that is done is a nullity. There should be certainty of law. That is one of the implications. And the Supreme Court has said, it is clear, jurisdiction is a matter that the court can raise suo motu on his own motion without the imprimatur, without being prompted by the parties. The court on his own can invite counsel to say, address this court on whether it has jurisdiction or not. That should have been done in this case. So there has to be certainty of law. The other implication, quite regrettably, is loss of confidence in the judicial system.
Right.
And that is the part that worries me. That worries, and I say that without any intention to disparage the courts or the judiciary. When citizens have lost faith in the judicial process of their country, you will now begin to see recourse to self-help. When disputes arise, people will be hesitant to go to court. That will also affect even investment in the country. Because foreigners, expatriate investors who want to come and invest in Nigeria, they want to be guaranteed that the judicial system is such that when you take a matter to court or when you are taken to court, you are guaranteed that the process will be in conformity with the rule of law and the due process. So that loss of confidence, and quite regrettably again, it is usually in political cases that we often see decisions that tend to make citizens cast aspersions on the integrity of our courts, which is why this has to be avoided. And I have always argued that while there is a genuine, legitimate, and cogent need and advocacy to properly fund our courts, beyond funding, beyond the welfare of judges, it is the judiciary that has to redeem itself. It is the judiciary that has to preserve its reputation, not the executive, not the legislature. The judges, the justices of this country must continuously stand up to their oath of office, to the judicial oath, to do the proper thing, so that citizens will not lose confidence in the court. Because at the end of the day, as far as constitutional democracy is concerned, the judiciary remains the most important organ of government, because it has to checkmate the executive, it has to checkmate the legislature. It has to even under military dictatorship, even in the worst military dictatorship, including the Abacha dictatorship, the judiciary was allowed to exist, despite the austere clauses and encroachment into its jurisdiction. But the judiciary was never set aside. When the military came, they would disband, dissolve the National Assembly, the Houses of Assembly, chase away elected members of the executive. The judiciary always exists. That shows the preeminence, that shows the importance of the judiciary. So that is another implication, loss of confidence in our courts, lack of certainty in the law. And this has to be addressed so that all Nigerians can have confidence in the courts to go to court and ensure that the right thing is done. But the good news is that this is a judgment of a court of first instance. So let people not disparage the entire judiciary on the basis of what appears to be a controversial judgment in Kano. There is allowance, there is the right of appeal to the Court of Appeal, and even a further appeal to the Supreme Court, which I believe that the parties involved, Labour Party and INEC, it is a pre-election matter, so INEC may not necessarily be the one to fight this. It has to stay neutral. The Labour Party and possibly Alex Otti will approach the Court of Appeal to have the judgment tested. And that is the way to go.
Okay, it is assumed, because we don't even have to be lawyers before we can say that it is assumed that the honorable judge, of course, should understand everything that has to do with the laws and all of the standards that were, that have been laid down towards this issue, especially the issue of jurisdiction that you mentioned, and pre-election matters, the time frames by which all of this should be sent in or filed, as the case may be. But this has come out now, as the case may be. Now, will there be consequences? What kind of consequences on whoever understands that this is supposed to be like this and things don't function that way?
For me, I think that is a question for the judiciary itself to answer. But my position as a Nigerian, is that when judgments of courts such as these are delivered, it is also an opportunity. It is an opportunity for the judiciary and the institutions of the judiciary, including the National Judicial Council and, of course, our appellate court, particularly the Supreme Court, to be unequivocal that certain things shouldn't just happen. So, regarding whether there will be consequences for this, it is not for me to say. But what I am certain about is that my lords, justices at the Court of Appeal and possibly the Supreme Court will have the opportunity to review this. Because, as I said, it worries some of us that this had to happen. I cannot explain it. It is quite, hard to explain that for a matter that was filed on the 11th of May. Leave even the issue of jurisdiction. Judgment was delivered on the 18th. When was the case assigned, as I asked? Because when you file a case, you don't just go to court and have a judge hear it. It has to be assigned to a judge. And I don't think the Honorable Justice Yunusa is the only judge in Kano, division of the Federal High Court. And even under the party's direction, regarding pre-election matter, there is no allowance for forum shopping. If a matter and the primary of a party takes place in Abia State, you have to go to the Abia division of the Federal High Court, or the division that is responsible for that state where there is no where the Federal High Court does not have a division. You have to go to the state that has jurisdiction territorially regarding that matter. So the distance from Abia to Kano is a long one. So I don't understand why this had to happen. But as I said, it is possible the late judge had his reasons. We will need to see the entire processes file. And one of the areas I even want to understand is even the gravamen of the case itself. Because I have taken the position, and the Supreme Court may rule otherwise, but this is my position, that even on this issue of submission of membership register, yes, the Electoral Act says that parties should submit their membership register to INEC 30 days before primary. Does it bar parties from admitting new members after the submission? The answer is no. A political party has the right. What the Constitution says is that you should be a member of a party. You should be sponsored by that political party. Where there is evidence of membership and sponsorship by the party, the matter is closed. That is my view. That is my view, because what submission of the membership register to INEC does not mean you cannot admit new members. And even parties grant waivers to new members. Exactly. All political parties in Nigeria. Exactly. All political parties.
So what happens to the new persons coming on board?
Well, they can be granted waiver to contest. If you join a party a week to primary and the relevant organ of the party grants you waiver, you can participate in the primary. It is forum domesticum. It is internal affairs of the party. And the Supreme Court has said matters of party membership is exclusive preserve of the parties. So I don't share the view. I don't share the jurisprudential argument that non-submission of membership register to INEC 30 days before primary invalidates the primary or the candidacy arising therefrom. I don't share that view. And I know that in my home state, Akwa Ibom, this matter had even been litigated up to the Supreme Court, where Kano, the APC candidate, contested, and then Senator Itainan, who was an aspirant in the primary, went to court to challenge his candidacy. Part of the grounds was that Kano had joined the party late, and that his name was not even in the register of the party. The matter was litigated up in the Supreme Court. It was decided in favor of the candidate. And I know that the Court of Appeal has also pronounced on this issue of submission of membership register regarding Peter Obi. So if this was even what led to this case being filed, ab initio, was the attention of my Lord drawn to this decision of the Supreme Court and the Court of Appeal on the matter? So these are the questions. And lawyers must also take responsibility for some of this, public ridicule sometimes, not all the time, that our courts have to face. It is lawyers who file this case. You'll be surprised it is a very senior lawyer. Not young people like us. There are things you will not have the boldness to do. It's not the entire senior members of the profession, but some people within the legal community are responsible for the continuous deprecation of our courts. And we see this every day. A lawyer filed this matter. And by the rules of professional conduct for legal practitioners 2007, you shouldn't just file a matter that you don't believe in. Before you file a case for a client, there are questions you have to ask yourself. Is it meritorious? Is it arguable? Are there recondite issues of law that can be argued? Is the court clearly bereft of jurisdiction? Does my client have the local standard? Is this matter statute bad? Did the lawyers interrogate themselves regarding this question before they filed this case? So let's not just say, oh, the judge had given a controversial judgment. How about the lawyers who filed this case? So it is a question that my constituency has to address, because we must not allow few divisions of our courts that are politically charged or controversial to be used to cast aspersion on the entire judiciary, because the majority of our judges are honorable. They live by their oath of office. They work under very difficult circumstances to maintain our judiciary. And we also have a responsibility to shield and protect them, because judges do not speak. That is why when this NAN report came out that the judge has clarified, I said it is fake news. Judges do not speak to the media. Judges only speak to their judgments. No judge in Nigeria will go to the press and issue a statement to clarify a judgment that it has given. So, it is not possible.
All right. We'll look forward to developments in the coming days with regards to how the Labour Party and Alex Otti respond to this matter. But we must thank you, Ine Behe-Fiong, a lawyer, for your time on the program.
Thank you for having me.
Thank you
it's
so
my pleasure.
Much. Thank you.
Thank you.
Thank you.